Good morning. The Metropolitan Board of Ethical Conduct Committee will now come to order. Today is August 25, 2023, and I detect a quorum. And that will bring us to the first item on our agenda, call to order, and I'd ask our clerk to take the roll.
Chair Vianney.
Present.
Ms. Carpenter.
Present.
Mr. Gutierrez.
Here.
Ms. Lewis is not present. Mr. Patton.
Here.
Mr. Spraggins. Here. Ms. Young.
Here.
And Councilmember Toombs.
Present. Okay, thank you. And now before we move to
one more chair?
second item, I will be off agenda for a moment to welcome our newest member. Thank you. Who's just joined us today, so thank you for joining us. Welcome, and I appreciate having you here.
Thanks for having me.
Okay. We have a full calendar, full agenda, so we will get started with agenda item number 2, which is discussion regarding the reasonable restrictions on public comment period required pursuant to public chapter number 300. All of us have seen that is effective July 1, 2023. We have a new law regarding, Governor Lee has signed regarding public comments. One of the questions for us as a board is to decide how we want to proceed with that in terms of having sign up, as has been suggested in advance by the door, and whether we want to have any restrictions on the time limit and so forth. So just a very brief discussion. We have, for this meeting, followed the recommendations of the law department with respect to providing notice of how members of the public can participate in public comment with us, which will be in the agenda directly here. In this case, we have it in number 3. It will be in our agenda in this language to make it very clear. Our agenda is posted. How much in it? I'm going to defer to our.
Typically at least 7 days in advance.
At least 7 days will be posted, so the public will be able to look at our agenda, see what the issues are, know how to sign up for public comment and so forth. So I think the only question, if everyone is comfortable with proceeding this way, the only question for us is whether we want to restrict it to a number of people or minutes per person, so forth. Any thoughts?
I'd be in favor. I don't think a restriction on the number of people is necessarily fair, but I would be in favor of a time limitation.
Okay.
Something reasonable.
Number of minutes per person.
Right.
Okay. Yes.
For council meetings and committee meetings, we do 2 minutes per person.
Okay.
I was thinking maybe 3, but 2. I'm fine with 2.
Okay.
2 minutes per person sounds good.
Yeah, and it's consistent then across, so.
Yeah, that makes sense. That's what you do.
Sounds reasonable.
Okay.
And then can signups be fielded ahead of time through like an online form, or is it just solely at the door?
Are you,
Like can people sign up ahead of time for the meeting, or is it just solely at the door?
So-
and if you're late, then you're not on
I
public
see.
comment period?
I see what you're saying. So you're saying if you're late, if you don't come right away and you're not signed up beforehand and you miss the public
Yeah.
comment period. So, but is your suggestion
Or
that they
like
should
I'm just asking.
Yeah, yeah,
like,
well,
yeah. So I don't know, right? Like
This is board discussion, so do
Yeah.
you have a proposal?
well, like for some reason I feel like people should be able to sign up ahead of time. I've seen other meetings where they close the sign-up list like right when the meeting starts, and so that's why I think something like that makes it more accessible. Just making sure.
Okay.
Plus, it's always hard to find parking and come here.
Okay. So, it's really important. So, what do we say here? We say that have to sign up at prior to the beginning of the meeting. If we said prior to the public comment period, because if someone misses the public comment period and we're further in the agenda, are you?
No, I don't think we should go back to that.
Okay,
It's just a matter if they can sign up online.
Well, my only hesitation, if it's electronic, so it would be to the clerk's office. And is that would you have the capacity to receive it and to?
Yeah, I
work
could just
with it?
add on the agenda, if you would like to sign up for the public, please email our Metro clerk email address.
Okay, perfect.
That would be fine with us.
Okay, so that's how it would operate. So any comments or thoughts about that suggestion?
So the thought is that somebody could sign up in advance, or they could sign up when they got here before the
Either or,
meeting. Sure.
either or, just as an option for folks.
I think I need a clarification. So if someone signs up for a comment, but they don't arrive until after the public comment portion of the meeting is over, will they still get to make a comment?
I think that starts creating a little bit of chaos with our agenda.
Yeah, I just think we should
Yeah.
clarify that
Okay,
piece.
I think that's a good idea. What do you propose?
That you allow signups ahead of time or at the door, but the public comment period is allotted on the agenda and no comments will be taken after that
Okay.
portion of the meeting.
So if someone comes in during public comment, they can give public comment, but once the public comment period is closed, there'll be no more opportunity to make public comment that meeting.
Correct.
Is that everyone's understanding? Mr. Pat? Okay. All right. Would someone like to make a motion to that effect?
I'll so move to adopt Ms. Young's proposal.
Okay. Second?
Second.
Okay. So just to make sure everyone understands what we're voting on, that we will, as Mr. Gutierrez's suggestion, we'll combine these into one motion, that we will proceed with public comment period as follows. In addition to having the sign up at the door at the beginning of the meeting, the notification of public comment period will be modified to include the email in the clerk's office so that people can sign up for public comments in advance. The clerk will have a record of that, so we'll know when we come to meeting. We will add that to whoever signed up in advance. That the public comment period will not limit the number of individuals who can speak, but will limit the time to 2 minutes. And that even if someone has signed up for public comment, but does not arrive until after the public comment period has ended, at that point, they will no longer be able to make a public comment in that meeting. So that is my understanding of the motion. And we have a second? Who was seconded?
Yeah, Patton.
Okay. Any discussion of that? Is that clear? So we're going to take a vote on that. We'll do it by roll call.
Chair Deani,
Yes.
Ms. Carpenter,
Yes.
Mr. Gutierrez,
Yes?
Mr. Patton,
Yes.
Mr. Spraggins,
Yes.
and Ms. Young.
Yes.
6 in favor.
Okay, so that's passes. So that's how our public comments will proceed going forward in this board. Okay, that brings us to the next item, which is item number 4, approval of the minutes of our April 14, 2023 meeting. We have all received a copy of it. I hope we've all had a chance to review it and read it. Is there any questions or discussions regarding the minutes? Hearing none, would someone like to move to adopt the minutes?
Move to adopt the minutes.
Is there a second?
Seconded.
Okay, any discussion? Hearing none. All in favor of adopting the minutes, say aye.
Aye.
Any negatives, any noes? Hearing none, they are adopted by voice vote. Okay,
Chair,
yes.
is there anyone here that showed up today for public comment period?
Nobody's.
Oh, thank you. Thank you, yes, you're right. Thank you so much, so much for paying attention. But you're right, did we check? How do we?
Yes, I
You just
checked before it came in.
And you checked right prior to my skipping it and moving into item number 4?
Yes.
Okay, thank you. Okay. Thank you for that reminder. Okay, that gets us to item number 5. Notice of appeal rights and all.
After a contested hearing by this board, a party may appeal to the Chancery or Circuit Court of Davidson County by filing a writ of certiorari within 60 days. Any party wishing to pursue an appeal is encouraged to seek independent legal counsel to ensure that deadlines and procedural requirements are satisfied.
Thank you. That brings us to item number 6 on the agenda, which is discussion and consideration of the complaint of July 27, 2003, against respondents Jones and Finch. We have all received a copy of the complaint of July 27th and the legal memorandum regarding the complaint dated August 10, 2023. I hope everyone has received it and reviewed both of the documents carefully. As is our practice, we start our discussion of complaints that come before us with giving an opportunity for the legal department, Ms. Ecke, to summarize for us the law department's memorandum on the complaint. So I would ask you to do that now.
Okay, sure. I'll provide a brief summary. A complaint was filed against 2 members of the benefit board. The complaint alleges that the board members abused their public positions based on comments they made during a benefit board meeting. The complaint alleges that the comments were biased and discriminatory. At the June 6th benefit board meeting, the benefit board discussed whether to amend the Metro self-insured medical plans to add coverage for gender reassignment procedures that are deemed medically necessary to treat gender dysphoria. The comments alleged in the complaint include statements referring to transgender individuals as subgroups, and comments such as, "My God does not make mistakes." As reflected in the Department of Law's report, it's the Department of Law's opinion that the speech described in the complaint does not involve ethical matters. The speech outlined in the complaint involves debates on policy matters of public concern and does not fall under the definition of ethical standards as intended in state law and the standards of conduct. The state enabling legislation and the standards of conduct are aimed at disclosures of personal interests, financial improprieties, improper influence of public officials, and acceptance of benefits by officials. So it's the Department of Law's opinion that the allegations in the complaint, if true, would not give rise to a violation of the standards of conduct. Therefore, the Department of Law recommends that the board dismiss the complaint filed against the 2 members of the benefit board.
Thank you. Does anyone have questions for legal department regarding the report, the law department's report? As I, again, as is our practice and procedure, I'll just state again, and particularly because we have new members, our job is to consider the complaint. We hear from the law department, which gives a legal report as to recommendation to dismiss or not. And we as a board consider the complaint, consider the law department memorandum, and then within our judgment and discretion and after deliberation can decide to agree with the law department's report in part or in whole, or to not agree with it in part or in whole, and to proceed going forward. So that's what our charge is and what our opportunity is. So that said, let's open it up for comment and discussion.
I don't know if this is correct, because it's my first meeting, but, you know, like, I feel like these comments are pretty bad, like, from, in June. And like, just because it may be legal doesn't make it right. So I don't know.
Can you speak up, please?
Yeah, sure. So I just feel like these comments don't sit with me very well from a gut reaction. And I feel like, you know, just because of a legal opinion, it doesn't make it right. So I don't know what this board does in that case or how that proceeds from here.
Well, I think that's a really great comment question, and helps us because, you know, who we are as a board is really important, and the types of complaints we receive and what the purpose of this board is really important for all of us to understand and to kind of try to explicate to the extent we can. So as a board, we are charged, we have 2 sections of the Metro Code that we are responsible for when complaints come to us from those 2 sections. And particularly for new members, and it took me a while when I sat on this board to figure out what the 2 sections were. There's the code that's the standards of conduct and disclosure, which is what is being triggered here, which is referenced here, and then we have the lobbyist code provisions. That's our jurisdiction. So in order for us to move forward on a complaint, we need to understand and agree through deliberation that the allegations trigger one of the specific provisions that we're in charge of considering. In this case, this was brought under the standards of conduct. So we have very specific code provisions that we are to be considering. They were brought under this, basically subparts, provisions K, O, and I, which are set forth in the memo. So, my understanding, just to summarize, my understanding of the law department's memorandum, and I'll again ask law department to correct me or anyone else correct me if I'm not summarizing it accurately. My understanding is that there are allegations of speech that was concerning, to your point, the law department doesn't take opinion on that, but there's allegations of speech. And an allegation that the speech was discriminatory.
Correct.
And bias. And that triggered our standard of conduct subparagraph K, O, and I specifically. And what the legal department's memorandum does is looks at those specific provisions. So for instance, on page 3, it looks at I, which is what employees can and cannot do in some substances, in part, improperly secure unwarranted privileges or exemptions for themselves, relatives, or others. K, which speaks to giving shall not give reasonable basis by their conduct for the impression that any person could improperly influence them. And O, shall not accept other employment or engagement outside activities which might impair their independent judgment. Those are the code provisions that govern what we do. What we're discussing is whether the allegations within the complaint trigger those provisions. That's the question. I think that what I took from footnote 6 of the law department memo really speaks to your voiced concern that the language that you read in the allegation was concerning to you. Footnote 6 of the law department memo says that speech, which could be offensive, could be concerning, still doesn't trigger necessarily an ethical violation. It could be offensive, but there are First Amendment protections that the standards of conduct and these paragraphs that we're looking at do not regulate speech, offensive or non-offensive speech. They don't regulate speech per se. And when speech is on a policy matter of public import, First Amendment interests can actually, and protections can actually attach to that speech. I'm going to defer to the law department. Am I summarizing the position of the law department correctly?
Yes, that's correct. That is that, like you stated, this board's jurisdiction is pretty limited. And there are things that go on in boards and commissions that may be concerning, but that's necessarily within the jurisdiction of this board to rule upon, because your jurisdiction is limited to ethical matters as reflected in state law and the standards of conduct.
So if everyone on this committee had an opinion, hypothetically, had an opinion that any particular statement made by a public official or were offended by, whatever it was,
Sure.
that is not sufficient to do anything within our jurisdiction. I mean, if we can't tie it to the standards of conduct.
That's correct.
It's not our offense or anyone's offense. It has to tie into the standards of conduct.
Correct.
I will say, and for those of us who've been here forever, Mr. Patton and I, and you two are getting fairly senior as well, we have had a case that also was kind of not dissimilar in the sense that there was a member of an official in a board meeting that used language that several members of the audience actually that were very offended by it, and it was in the nature of a racial slur. And there, in that case, just to provide this background for you, the speech, irrespective of what anybody thought about the speech, didn't trigger an ethical violation under the code standards of conduct for us. And there were First Amendment rights that attached. So, and so that's a case that we had here before us in the past, which was with that kind of configuration. And I don't know if that is helpful or answers.
No, it's fine. I was, not super sure, so I just had to ask, but like.
Yeah, absolutely, but do you have, and what are your thoughts about it all, and anyone here, I think?
I have something to say.
Yes.
Is
Whatever.
she a member of the board?
Reverend Lewis.
Yes.
Oh, okay, good.
Reverend Lewis, president of
Would you
the-
like to sit here? Would you like to join
I'm
us?
fine right here.
Okay, thank you for joining us.
Historically, I'm gonna deal with it from the civil rights perspective. We have dealt with slurs and names pretty much throughout our life, and it's okay. It's been and I hope I'm saying this correctly. We have witnessed great commentators, actors, singers who've made some statements, and it has ruined their careers. Although we may not have the power to administrate, I agree with him that we have to be cognizant of statements made such as these, and then just looping in under the law to be protected. That's my concern with it. It's critical that we understand that to certain groups of people, certain things can impact them sometime for the rest of their lives. So that's just my comment.
Thank you, Ms. Lewis. I think that I find the statements offensive and possibly discriminatory. What I also think is that there may be a forum for challenging what the action that the board took, as discriminatory, motivated by discrimination, and that's not this board. We do have a pretty limited mandate. So when I was looking at the law department's memo, I didn't find the first two sections seem like a very close call in terms of, getting, using their position to secure privileges or exemptions for themselves. It didn't seem like that really was what was going on here, or that finding that some person can improperly influence them, especially because I think the allegation of the complaint is that it was a religious belief, not really a person per se, I guess, influencing them. The third one, the text says, engage in outside activities which might impair their independent judgment in the performance of their public duty. I thought that was a close call. Those words at least seemed to match. But I was persuaded, by Metro Legal's point about, our mandate has to do with ethical standards. That is pretty well defined. We are not necessarily the right body to police whether the benefit board made a decision that was based on discrimination or not. And I think there is a body to make that decision. So, for me, it would be a different matter if one of the board members said, if I don't vote against this, my pastor is going to kick me out of my church or something like that, because then you start to see a material benefit for somebody. But this was just mentioning, and it may have been improper to mention, it may have been improper to rely upon the religious beliefs or personal views in making this decision, but I think that's something that can be challenged probably in a court of law, not the Board of Ethical Conduct. So that's how I'm viewing this.
I think Mr. Spraggins summed it up very well from my perspective. I agree with Mr. Gutierrez as well that the comments are offensive, but given the very limited jurisdiction of this body, I don't think this is the place to adjudicate, whether those comments have violated a standard that we're not in charge of enforcing. So unfortunately, I feel like our hands are tied, and the law department's recommendation to dismiss the complaint seems warranted.
I agree with those comments.
Any other thoughts or comments?
Sometimes we have to take actions that we don't like.
Right, we have the
Personally.
jurisdiction that we have.
That's right.
Right, and I think the comment about what is the right forum is always a relevant question. Are we the right forum or are we not? With that said, I don't know if any, and I do not want to, we have times, if there's any other thoughts or comments or reflections or questions of each other or positions, this is the time. And if not, and we're ready for a motion, I would ask someone to make a motion.
You see Mr. Gutierrez wrestling over there, so I didn't know.
I know. It's just,
Right, we take your time.
Yeah.
These are,
so as a non-Christian, I find it very troubling. And I do think that's actually a real kind of thing in sort of decisions around human benefits. This is actually, I think that is actually very relevant. And invoking the name of God, for me, is very troubling in sort of making this decision. So I don't know. And speaking to someone who currently doesn't identify as Christian, it's very troubling. So I don't know.
Let me just ask a question. Do you, when you look at the standards, the three standards, do you believe that there's one that the conduct violates? I think that's really the question.
Yeah, and that's tough because the outside influence, specifically is the matter of faith and how that ties in. I just don't know. That's where I feel the rub a little bit. But
let's look at that language. That's what we're doing. Let's look at the language. Are you talking about K? Oh, the language
I think it's
under?
O.
Oh,
Yeah.
Well, I don't know if it actually influence and this is influence, so I'm not sure which one you're looking at. Do you mean K or O?
It should be K.
Okay. So an employee shall not give reasonable basis by their conduct for the impression that any person can improperly influence or unduly enjoy their favor in the performance of their official duties, or that they are unduly affected by the kinship, rank, position, or influence of any person. And I think that was the inspiration for your hypothetical, is that right, Mr. Sprague?
Yeah, that's where, if my pastor hypothetically said.
Yeah.
That was, so that would be an instance where if you had that allegation, then you are now tightly within this language arguably.
And by person, it's a natural person, right?
Yes, I would.
It could be a corporation. What I mean, in the context of ethics, for example, if you have a corporation telling you that you have a relationship with,
We'll give you this contract if you
do this.
Right.
So that's, that kind of situation.
But we're going to take our time with it. I mean, look at the language, and if you want to, should we look at any of it? Do you have?
No, I don't know what sort of, like, there's no action, I just feel so compelled to speak this way.
Yes.
Myself,
I know you're waiting to hear from me, ain't you?
I always am.
We've been around this board a long time.
We have been.
Been here together, and we've seen a lot of complaints come here. I understand the language that was said in the meeting. It is offensive. And I agree with this, it's offensive. And I'm not gonna sit and say it's not. But I just want to be clear about it. If it's not a violation of this ethical conduct, it's nothing we can do about it. Regardless of how people feel about it. We all got our feelings, but we are here and we go by the rules that we are governed to. So that way, that's why I didn't say too much about it. But I have to say something because I know you're looking at it. But I just believe that it's not a violation here. I just move to proper law.
Okay, with that said, I invite a motion.
I would move to adopt the recommendation of Metro Legal and dismiss the complaint.
A second.
Okay, we have a motion, we have a second. Any further discussion? Hearing none, we'll do this by roll call.
Chair Dion,
Yes, I approve of the motion.
Ms. Carpenter,
Yes.
Mr. Gutierrez,
Yes.
Reverend Lewis,
Abstain.
Mr. Patton,
Yes.
Mr. Spraggins,
Yes.
and Ms. Young.
Yes.
6 in favor, 1 abstention.
So what we have just done is, as a board, is we've dismissed the complaint basically for the reasons discussed, and we'll put our decision in writing and issue it to the parties, and that will be done. So there will be an order to that effect that will be published and received by the parties. Okay.
In the case of dismissal, because we agree that this is not maybe the forum for this, does that come with a recommendation where people should go?
That's really a matter really outside the scope of our purview to give legal advice to anyone regarding how they should proceed if they have lingering concerns about the allegations. Okay, that gets us to the next item on our agenda, which is item number 7. And this is a discussion and analysis of the complaint and Metro legal.
No, I'm sorry. I'm just.
I hate to miss a laugh.
No, I was looking at Councilmember Toombs, and she was also looking back at me.
Okay.
I was only looking at her because her name is listed as on the complaint.
Yes.
Yeah, that's all.
Okay.
Do you think she shouldn't participate?
Right.
That's my recommendation.
Yeah.
I think that's probably what she was gonna do anyway, but only because, she's
Yes.
one of the individuals
Yes.
that the complaint is against.
Yes. So I think I might have missed. So yes, item 7 is the complaint raised against 13 council members. And did I miss an exchange regarding?
No, I was
No.
just, no, there's, no.
I think the question is recusal.
Well, let me add something to that next. I need
Yes.
to recuse myself from this one because I represent Councilmember Suara in a lawsuit against the state with respect to the cutting of the council down to 20 seats. And I've tried to figure out if there's a way to participate in this without having an outside observer reasonably question if I was giving preferential treatment to my client, and I don't see a way to do that.
Okay. Okay, so there's one recusal. Are there recusals?
I don't get to vote, so.
You didn't get to vote,
Yeah.
right?
We still have a quorum without Mr. Spraggins, right?
We have a quorum, yes. Yes. Okay, so we are now on to item 7. We have all received a copy of the complaint as well as the memo from the law department dated August 14, 2023. I hope we have all had an opportunity to review them both carefully. And as I say, with all complaints, we will start with a summary of the law department's report.
Thank you. A complaint was filed against 13 members of the Metro Council. The complaint alleges that the 13 members of the council violated the standards of conduct by voting in favor of the new Titans Stadium deal after having received campaign donations from Titans lobbyists. The Department of Law reviewed the complaint and the standards of conduct and applicable laws. The standard of conduct state that anything of value does not include campaign or political contributions that are received and reported in accordance with state law. The complaint does not allege facts which reflect that the council members accepted or solicited campaign contributions in violation of state law. The complaint also does not allege facts which indicate that there was a quid pro quo with regard to the campaign contributions and the vote of the council members on the Titan Stadium. It's therefore the opinion of the Department of Law that the allegations in the complaint, if true, will not give rise to a violation of the standards of conduct. The Department of Law therefore recommends that the board dismiss the complaint filed against the 13 council members.
Okay, thank you. Okay, so we have all reviewed the complaint and the Department of Law's report. Are there any, we've heard Law Department's explanation of the report. Are there any questions or clarifications needed from the Law Department? Okay, so then we can move into discussion of the complaint and report. And again, I know that the code sections are detailed. And here we're actually now, here too, we are in the standards of conduct, but because it involves also, it also brings up our lobbying side of the code as well. I mean, these are the two sides we have, standards of conduct under the ethical code as well. We also are charged with the lobbying registration and disclosures under the code. In fact, it's an item that will be on our agenda for later this meeting. And we have reference to state law. And I just remember that when I was new to the board, it all seemed very confusing. So we can take the time if there are questions even about our jurisdiction, or what's applicable. Any question anyone wants to ask, we have time to really review so that everyone understands what's alleged, the provisions that are referenced, what law department is saying about those provisions. So, because if we need to be able to make sure we're all understanding it so that we can put our heads together as a board, deliberate, and make a decision that is knowledgeable. So again, I'll invite any questions. Otherwise, you're going to make me do all the talking.
I would just note that I think that the legal department's analysis correctly points out that there really, other than the complaint is brief. It's a short letter, one attaching the amounts that the council members allegedly received. I don't know if they did or they didn't. I guess that's probably correct. But assuming that's correct, the exception for campaign contributions is pretty clear. That does not constitute anything of value. And then as far as the other subsections, I think the complaint is devoid of facts that actually support a violation of the other subsections. I don't see the factual basis. So I would agree with the analysis.
Okay. And so let's just spend a little bit of time just talking about it. So everyone's kind of, so the complaint is alleging that the 13 respondents received campaign contributions. And the information, to the point you just raised, the complaint says the information comes from the Davidson County Election Commission. That's where the information came from. And there were certain votes taken after those donations. The law, as the Law Department memo points out, campaign contributions that are received and reported pursuant to state law are not part of the standards of conduct that we are charged with considering. And so political contributions are actually defined in one of our code sections on the lobbying side of our jurisdiction. Political contributions or campaign contributions includes any money or deposits payments made for the purpose of influencing a measure or a nomination for election or the election of a person. That's what a political campaign contribution is, within definitions of the code section that we have under our jurisdiction, the lobbying code. That's what it is. When you give money to try to influence something, a measure, a vote, a nominee, something, that's what it is. In Tennessee, if you have a campaign, a political contribution or a campaign contribution, there's a state law which tells you what you have to do about that. And that state law was referenced in the department's memorandum on page 4, Title 2, Chapter 10 of the Tennessee state law is cited. And the Tennessee state law says if you're a county, at the county level, and you receive a political contribution or money to influence you through a political or donation or contribution, then you have to do certain things. And it's very regulated. You have to have a treasurer, it has to be filed with the state. You have to have a campaign treasurer. You have to have reports. And you have to let the county election office know about that. So that's what the complaint says. That's where they got the information from the county, Davidson County election office. So that's where the filings were. So that's how we deal with, and I'm going to ask anyone to jump in. I know you're recused, but hold it if I say something that's not accurate. But so that's how political contributions and campaign contributions work. There's a whole separate law that the state that requires things that happen at the state and the county level to make sure that the public understands who's giving money to whom and who's trying to influence whom with money. There's no, and that's what I understand what the law department is saying is here, yes, there were political contributions in these amounts. In fact, the complaint was saying that the information in the complaint comes from the county office of elections suggests that it makes it kind of, the facts are that they did report under the state law. So therefore they're not, so that's off the table. And I think this is what Ms. Carpenter was getting at. When you look at what else is in the complaint, like what are the other allegations of the complaint, there's nothing else in the complaint. There's no other allegations. So there's, as was pointed out in the law department, there was no allegation that there was a quid pro quo, that if you give me this, I promise I will do that. There was no allegation of some type of agreement. So there are just no facts alleged here that would trigger the standards of conduct that we have in front of, that we are responsible to consider. I'll ask for anyone to jump in if I've misstated anything. But that's my understanding of what the law department is saying in their memo, but that's also my understanding of the way the law works here. That's the scheme. That's our statutory landscape. Because the question of political contributions to influence policies, important matter. And we, particularly as a board, who's charged with understanding the standards of conduct and lobbying, and in fact, we're going to get to it later in this agenda, we have to understand how all that's supposed to be working and who's reporting to whom, and to make sure it's all being done. And when we get a complaint, we have to look at the allegations and consider what's being alleged to see if there's anything within our jurisdiction that we can do something about. But to go back to Ms. Carpenter's point, because political contributions, there's no evidence that the political contribution wasn't handled correctly. In fact, the evidence in the complaint is that it was handled correctly as a political contribution. It was reported and went to Davidson County has it recorded. Separate from there are no allegations here for us to do anything with. So sorry to be long-winded, but I just, I guess I think that's where I land with respect to this complaint. And I'd ask for other comments.
I have comments. First, I agree with your summary and the analysis from the law department. We are dealing with a situation of a controversial vote on the Titans stadium deal that many people are upset about and not in agreement with. But as it pertains to this complaint, the allegation of just saying these council members received contributions from a Titans lobbyist and then voted in favor of the new deal, that doesn't rise to the level of an ethical violation because they are political contributions. And you could easily point to others who may have made political contributions that may be against the Titans deal, and they might be upset that the deal was approved by these members, but their contributions aren't noted. So where's the influence? I feel like there's a nexus missing, as the law department described it. There's a lack of quid pro quo here to say these members voted that way because of the contributions they received from the Titans lobbyists. And I was also struck by the fact that this happens all the time at every level of government. People contribute to candidates and people in office to support them, their candidacy or their reelection, and maybe it'll buy them something down the line, but they have no way of really knowing that. So when you have contributions that are properly reported, that's sort of the balance that we've struck as a democracy, that okay, we know people are giving money to support candidates or to influence our government, but we want it to be public and disclosed in the proper way so that we as citizens know if there is something that would rise to the level of an improper influence. And here I just don't see it.
Yeah, and I will say, and yes, to your point, I mean, even that's why I read the definition within the lobbying statute specifically says political contributions are money given to try to influence. But I will say that, and it is not to say that if you receive a political contribution and report it, that fully immunizes and nothing else bad can happen, because, and here I'm going to do a hypothetical, because it's conceivable you could have a written agreement that give my campaign $5,000, $1,000, and I will do X for you, and I'll report it to properly. So it doesn't that it immunizes it if there are other facts, but you would need the facts to be alleged. And I think it's why the law department's memo refers to this as skeletal. I mean, I think the word skeletal is because the only thing here is the receipt of political campaign funds. So we just don't know anything else. We weren't told anything else. All we're told is that was the problem, and as to that, there's no ethical, in my view, there's no ethical violation because it was improperly reported, yes.
I think the key call out for me is that you're dealing with a multi-million-dollar dynasty of the Titans. If it's, that's a huge revenue. And when you look at the contributions, you can clearly see that the amount of money would not subject a council person to influence. It's just not enough in the donations overall. So I think that's the key call out, is that the donations are so minimal. These campaigns cost thousands, sometimes millions to run. And so that there's just not enough money there to me to connect to any kind of influence. If it was 50,000 or 70,000 in donations, it would look like maybe they're trying to influence the council person. But the numbers are so low, and the donations are small.
It was also interesting that on the list of donations, there was a council person that received a political contribution from the Titans lobbyists that wasn't named in the complaint. So I was wondering, did this person not vote in favor of the stadium, or why wasn't that person included in the complaint? So I think it raises another, point to your point about it being a skeletal complaint. Like, you don't really have enough information or any information to suggest that this was a quid pro quo, because I could imagine that the Titans lobbyists probably made contributions to all the members of the council, and did all of them vote in favor of the stadium? I'm guessing not. So yeah, it's really hard to draw a conclusion based on just the political contributions.
Do you want to make a motion?
Sure. Yes.
I'll move to adopt Metro Legal's recommendation and dismiss Mr. Bender's complaint.
I second motion. We have a motion to adopt the law department's recommendation to dismiss the complaint. We have a second on that. Is there any discussion? Any further discussion? Hearing none, let's take the roll call.
Chair Diani,
Yes.
Ms. Carpenter,
Yes.
Mr. Gutierrez,
Yes.
Reverend Lewis,
Yes.
Mr. Patton,
Yes.
Mr. Spraggins is recused, Ms. Young,
Yes.
6 in favor.
Okay, and so that we have voted to dismiss the complaint based on the reasoning because of there were no facts alleged that would allow us to act. We haven't, and I guess, I'll defer to legal counsel. Are they typically in a situation like this without prejudice dismissals? Or would that have to have been discussed? I mean, I guess they're really not with prejudice. They're not with prejudice, really. We don't have that formality.
Yeah, I mean,
So I guess they're all kind of without prejudice.
well, it's a dismissal of this complaint.
This complaint, right?
Yeah.
But
I mean-
without, right?
Yeah.
Yes.
Each complaint stands on
On
its
its
own.
own.
So just to make sure I'm clear, if another complaint was filed that had new allegations, we would still consider that?
Yes, we'll go
Yes.
through the review process.
yes.
If someone files another complaint.
Okay. Thank you all. There will be a written order to that effect submitted to all those parties. Okay, that gets us to item number 8. How are we doing time-wise? It's only 10. Okay. And now, item 8 is annual lobbyist reporting. And let's review and discussion of an updated report and draft letter to the Vice Mayor. We have as a separate item 9, Metro Clerk's update on lobbyist registration. So let's just talk a bit, just for background here on where we are with the lobbying reporting. And this is, again, not complaint-driven. This is just our general jurisdiction. When we, particularly for our new members, we receive a record on by March 1st, the clerk's office gives us a list of any registered lobbyists who fail to comply with the lobbyist registration code, which is to file by the end of January of every year a retrospective report for the entire prior 12 months, the prior calendar year, of all expenditures made, contributions, donations, anything given on behalf of a lobbyist client or the lobbyists themselves, and to a public official, metro official. And those reports are fairly detailed and the information requested. The lobbyist has to submit them all. The client has to sign them, I believe under penalties of perjury, and that all gets submitted in January, at the end of January for the prior year. If they don't file that report by the deadline, they get reminded, and if they file it after February 5, they have a $50 fee that they have to pay. And the clerk's office does all of this and manages this whole thing. We receive, as the board, we were recently given jurisdiction over this so that March of every year, the clerk's office gives us the list of lobbyists who have failed to comply. They've either failed to file the reports or they failed to pay the late fee. And we were given that this year, we were given it in April. And when we met to discuss it, well, we have been concerned, actually, this board for, I'd say a few years, that although we are to receive this information about what lobbyists are doing, we don't have any enforcement powers and can't even really recommend sanctions unless someone in the public brings us a complaint. There's no, even though we're receiving the report and looking at lobbyists who are failing to comply, we've been trying to get attention to this fact, I will say. When we last met in April, when we were looking at this list, which I think, is this also in the package for everyone? It is. We started asking questions like, if some lobbyists failed to file their reports last year, why should we allow them to renew going forward? That was, and we decided last time we all met together that we would try to bring to the attention to council that we have some concerns about this lack of ability to do anything. Our Metro Clerk, Mr. Kyle, wrote a draft letter, which is in our box, which in our package, dated August 25, in an effort to bring to the council through Vice Mayor's office our concern. And so we're now on the agenda item to consider the issues, articulate our concerns, look at the updated report, and consider how we want to proceed with a communication with the Metro Council, the Vice Mayor's office. Clearly, because of dates, we are in the middle of we will be in the middle of a transition over the next 6 to 8 weeks. So we likely, whatever we decide to do today, likely it won't be implemented until we get into the new administration in October, I think. So that's just a timing note. But I really want to thank Metro Clerk Mr. Kyle for preparing the letter. I think it's really well written. But looking at it, so let's just kind of discuss this. There's also the updated version of the 22 report.
Before we get to the report, I was just going to suggest maybe this letter should come from you instead of Mr. Kyle, just because he wears a lot of hats with the
Yeah.
vice mayor, and
Yeah.
we have one job.
Yeah. I think that's a good proposal, and I'd be comfortable with that. What does the board think?
I agree with
Makes
that.
sense? Okay. Yeah, and then I will say though, and I think this is a really well-written letter, I do think that there's one other thing that I'm concerned about, not only that the lobbyists that have failed to file, which is very relevant, but I think I have seen in at least one or more instances that a client of the lobbyist has lobbyists, the lobbyists fail to file, and the next year, the client gets new lobbyists. And when you do that, that's a loophole, because then you don't have that information. So let's just, not to pick on an organization, but let's just say Verizon. So as an example, if Verizon has 3 lobbyists and for the year 21, the lobbyists, I shouldn't be using, because I don't mean to be suggest anyone in particular, but Company A has 3 lobbyists for 21. The lobbyists don't file and don't tell us what money has gone from Verizon to public officials through their lobbyists. They just don't file, so they don't renew. And the next year, Company 1 hires new lobbyists. They've had a year of donations that aren't being recorded. Not political donations, that's under state law, but the other expenses, gifts and expenses that they're giving to council members. So.
And if you look at the updated report, the majority of them are not registered this year.
Right.
So that goes to your point.
Yes.
There's only, I think, 7 out of this whole list that registered for 2023, so
Right.
it's a significant
So
loophole.
what type of strengthening would you be looking for? Because council members, we have an ethics code that we have to follow as well, as far as what, we can't accept anything over $25. And then there's some exceptions to that, but you're looking at, like a scholarship banquet. If someone comps us a ticket, it can be up to $100. Like, we can't accept like big dollar things, and we have to report once a year anything that we've received over those limits.
Right. That's in the disclosure that all Metro employees have to prepare annual disclosure forms and benefit statements.
So I don't think that there is anything slipping through the cracks, because council members themselves have to report.
Yeah. Well, I think my view, and I won't speak for the other board members, and everyone should speak up, but if we have a lobbying reporting code, and lobbyists aren't reporting under it, and clients of lobbyists aren't affirming the accuracy of lobbyist reports, there's no purpose to have a code if no one's complying with it. I guess that's the concern. Why do we have a code, and why are we receiving reports? Because it begins to look like, well, we say it just for looks reasons. If we're not following up and making sure that there's actual reporting being done, and we're recording it, and members of the public can look at it. I mean, the whole point of having the lobbying code is so that members of the public can look at who's buying dinner for whom, and so forth,
But nobody really does that on the city council level. Like, this isn't like federal politics where you've got the big dinners that people go to. That doesn't really happen with local politics.
So so then there wouldn't.
I think the point, at least from my perspective, is to see who the lobbyists are, because a lot of times people want to know who's in the room. So usually your lobbyists, if there's some, big item on the agenda, your lobbyists are going to be there. And folks in the public want to know who those people are. They don't want them to just, think we're all everyday people, but they don't want them to there's a feeling that lobbyists are different, and so they don't consider them part of the general public. And so they want to know who those people are who are being paid to try to influence council members on particular legislation. And so I think, and I've never been a lobbyist, but I think for folks who are signing up, I mean, if someone is actively lobbying and not registered, that's a problem, because that's not being transparent. But if someone, they're like, my lobbyist contract is up, I'm no longer doing any work, it seems to me that those, like with the company A, they got 3 lobbyists, perhaps they were just on one issue, that work is done, so they've gone on, and maybe they do contract with another lobbyist for the next year.
Absolutely, and individuals' decisions to stop lobbying, to hire new lobby, and all that's fine, but to have the privilege to lobby, my view, this is to have the privilege to be registered as a Metro lobbyist, to be able to be in the room, paid to try to influence someone, one of the things you have to do is paperwork. And the paperwork involves, at the end of the year, you have to keep notes all through the year, every time you spend any money, and you have to report it. And if you don't want to be a lobbyist anymore, that's fine. Just put in the paperwork, because that's part
So
of
we're
the
saying people
responsibility.
submitted their report. Now, that's a different thing. If you've lobbied in 2023, you don't submit a report for 2023. Yeah, that's a problem. But if I don't register for 2024, maybe that's
no,
I think
that's
it's the fact that none of these, except for the 5 in the yellow, never reported.
Okay.
Yes, it's, in fact, I'm going to just say this so I don't forget. I think if they're received, then they're no longer out of compliance as long as they pay the $50, right?
Correct.
Okay.
But we don't have.
There are several that submitted reports but didn't pay the $50, so we have to deal with that issue too.
Yeah.
But that raises a question. So I understand currently we can't do anything unless we receive a complaint. What are our options if we do receive a complaint? Like, what are the sanctions or things that we can do in this situation?
Yeah, and that is spelled out in the code, and then we'd actually go through a hearing and have a hearing, do kind of the exact same.
Same process as
Same
kind of like we
process,
did
yeah.
today.
Yeah.
We'd have to decide, dismiss or go to a hearing and then have a hearing.
And after the hearing, if we find that there has been a violation.
Yeah, we'd have to pull that out. We'll pull out the enforcement section. Let me get right here. I've got it right here. Enforcement is 103. Action, penalty, sanctions, and appeals of decisions of the board. We could recommend, it's very similar to what we can do on the ethics side of it. If we, by affirmative vote, decide that someone's violated the lobbying chapter, we could recommend to council that the elected official or member of the board be censured, recommend to the violating elected official or member of the board that they resign their position, suspend the registration of the lobbyist, or prohibit the person from registering as a lobbyist for a period of up to 2 years. Metro clerk shall act to prohibit or suspend registration upon a decision of our board. D is direct the Metro clerk to issue a citation. E is to refer the matter to the district attorney for appropriate action. F is to refer the matter to the director of law with a request that appropriate civil action be instituted by the Metropolitan government for restitution or other relief.
Okay.
And I think the issue, I don't know if this speaks to your question, Kanika, but like, because we're strictly a complaint-driven board, we can't even have it be automatic that if you didn't pay your fee last year, you can't register again this year.
Right.
Which would
That's the
be,
problem.
seems to me like the most basic thing to
Right,
do.
that seems like a pretty straightforward.
Yeah, I was trying to see like the existing penalties, if we're fine with the way they're worded, it looks like we would just need another way to enforce or impose those penalties in the absence of a complaint. Is that what we're
Yes.
getting at?
We had actually proposed, I think a while ago, as a board, we were thinking, because we looked at what the Tennessee Ethics Commission does, and if you fail to file, they schedule you for a show cause hearing, and you come and you get a letter delivered to your house, and you appear before them, and they have fining ability for every day you don't file, you're fined. And I think we talked about that briefly, hypothetically.
I'm just disappointed that we don't have one Channel 3 viewer who wants to file a complaint and let us hear all this stuff.
Everybody,
Yeah,
I know.
nobody stays for this part of the meeting.
right. So here's perhaps a outlandish proposal. Strike it down. Feel free. We could, because it is it's getting to some extent late, we've been through a lot already. One possibility is we could stay now and work on this letter and then hold it until mid-October when there's, we could, and maybe this isn't, as I'm thinking, maybe it's unnecessary. I was going to question whether, as a board, we wanted to reconvene sometime before mid-October with the statutes, with our code, with the lobbying code, with the clerk's office showing us not only who's failed to file, but what the filings actually look like a little bit, like maybe a sampling, maybe a 5%. There's something like 132 registered lobbyists or companies and 98, one's, I forget which is which, one's the clients, one's the lobbyists, but under 150 of both. Some sampling of them, literally looking at what is submitted to the clerk's office, what kind of data exists. That would also help us inform, Council Member, I think Toombs was trying to inform us, that would also be another way of informing us, really what does it look like? Are people not, are they being filed empty? Because there has been no gifts given, no lunches, gifts, anything of value, so they're all coming in zeroed out. So here's the signature. We certainly don't want to make government inefficient or any of this, but to kind of educate us as a board a little bit about literally what does it look like, so that if we are going to be so bold as to make suggestions in a letter to the vice mayor, so that we at least have a sense of, real knowledge about what we're talking about. We really can kind of see it, have the clerk's office help us understand their process, how it works, what lobbyists are asked to do, what clients of lobbyists are asked to do, and so forth. So that would be something we could do. We could do some quick short form of that now and just stay for another, half hour. What are people's thoughts about that? And again, I'm happy to go either way.
You mentioned something happening in mid-October.
Oh, just the metro government, there'll be a new mayor, and the new council gets seated in October, first week of October, and then the vice mayor, we don't know when she will be sworn in, but probably sometime. Okay. So this council is ending next week. Technically, but I understand the council member too. You'll stay with us?
I am.
Thank you. We appreciate it. We appreciate it.
Well, the next president pro tem will be the ex officio
Yes,
member.
right. And they do that vote usually the first week of October.
I think it's the second week.
Second week of October, we'll have a new ex officio. The councilman pro tem is who sits on our board. So that changes every year. There's a new election every year.
So I guess I would either come back and do that meeting sometime in October, or I'm also comfortable sort of vesting our chair with the discretion to make a couple of recommendations that are consistent with what we've talked about, because we've had this conversation for 2 years.
Well, and I was also going to say, to the extent, it doesn't make a lot of sense to me to sit here and try to go through it now,
Right.
Without things in front of us. But to the extent, like this sampling, if we could get that emailed to us so that we can look at it when we have time, I would be interested just to see what these look like. I mean, and are we really talking about anything significant? I mean, it's significant that they're not reporting, but it'd be interesting to see a sampling and see what actually goes on. And then, again, I agree, you can make recommendations. You are more familiar, I dare say, with this issue than any of us. You've delved in to a big extent, and then come up with, maybe revised that would include the loophole, addressing the loophole and so forth, and then come back once we've got that stuff in front of us. That would be my preference. And I think we've got some time, as you said, because of the, and we may end up with another complaint and be back.
Right.
We can do it all at one time.
Right, and I'm also trying to capture a time when the clerk's office will not have late night 2 a.m. meetings in the month of September. I like to kind of push the work. This very brief break they get where they can actually sleep some. But maybe that would work with your scheduling if we did that and set up so if we pulled the sampling paperwork together, if I wordsmith this a little bit as a draft, we could then have another meeting in the last week of September, perhaps, and just to come, but to give you, could we get out the sampling? Can you send it to board members in advance of that?
Absolutely, yes.
So that everyone can have a chance to look at it, and then we can wordsmith together the final draft and take a vote on it, because I definitely would do it by vote. I would want the board to opine and vote on it, and then send that out in October. So something along those lines, roughly that type of schedule. So the new, when is the first council meeting of the new?
October
Tuesday.
First Tuesday in October.
First Tuesday in October, that's the first?
The 3rd, I think.
The first Tuesday in October, oh, I'm sorry, I was on 24.
Yeah, 3rd.
Yeah. Okay, that's when it all starts again, all the fun starts again. I'm going to throw out, what is Thursday, September 28th look like for folks?
I'm available.
September 28th.
28th, yep, Thursday, September 28th.
Yes.
Yep, okay.
Yeah, our meeting's typically at 9, is that?
It often is, we have moved it around and can on any given day, but.
9's fine by me.
Yeah, say that again?
9's fine by me.
9's fine.
That's better than.
Okay. So 9? Mr. Patton, is that possible?
September 28th,
Yes.
I'm good.
9, okay, then that works. So why don't we have a 9 a.m. meeting on the 28th? And before that, Mr. Kyle will send out, his office will send out to all of us samplings of the actual reports, and I'll work on a draft, some playing with this language a bit, wordsmithing some, and have a draft, maybe send it to Mr. Kyle, and he can get it out to folks the day before or something. And then we can meet and just briefly discuss all of it and make any changes we need at that time. Okay, so we'll have that scheduled, and that will really be the only, perhaps the only agenda item, unless a complaint comes in. Wonderful. Okay, so that takes us to the next item, the update of the lobbyist registration for 23.
Sure. Quick update, since we're just a little over halfway through the year. So far in 2023, we have 90 registered lobbyists representing 135 clients. And that's compared to last year. The total for last year was 98 lobbyists and 148 clients. We're almost up to what we were last year with several months left to go.
Oh, because it rolls in all during the year.
Right. New registrations are received all the time.
Oh, yeah, I see. Huh. So this is a greater number in both counts than it was at the same time, year over year, so the same time last year.
I didn't do a comparison at the same time last year, but as far as
Your
comparing to
sense.
the totals of last year, it's pretty close.
It's getting pretty close, huh? And they must mostly be up front in the year, the first 6
Yeah,
months, and it must just
usually most of them are
dwindle.
renewed by January, but throughout the year, we do get.
Yeah. Okay. All right. Okay, any thoughts or questions about that? Okay, great. So next steps in scheduling, we've done that now. We know that we'll meet again on 9/28/23 at 9 a.m. in this room. The topic will be lobbying. Okay. Any other questions or comments? Anything else that anyone wants to bring up? Hearing none, we now will adjourn. So thank you all for being here.